Good afternoon, everybody. Councillors of the LPC, welcome. Colleagues, officials of the Legal Practice Council, senior managers, directors, if they are in attendance, welcome everybody to this important session that has been offered by the Legal Practice Council. The session has been organized to assist legal practitioners with the knowledge on how to draft bills of cost, legal fees, contingency fees agreements, Rule 54 of the Legal Practice Council. This session was organized based on the number of complaints that we received as the Legal Practice Council, and we saw the need to have this session in order to assist legal practitioners with the knowledge or the know-how of how to do this. The housekeeping rules, all attendees will be muted, so please remain muted. If you have a question, please post your question in the chat box there on your screen. Please type your question in there. Mr. Contingency is going to read the questions at the end of every presentation. And the webinar will be recorded. The recording will be shared after our internal processes are conducted. Please remain unmuted. There's Giselle who is unmuted. Please remain muted. Thank you. To avoid interrupting the recording. Thank you. Giselle, please remain muted. All right. Thank you. To avoid delays, we are struggling to get in the two first presenters. But for now, we are going to start with the last presentation of Mr. Ashwin Reddy, wherein he will be presenting on Rule 54 of the Legal Practice Council. The rule provides an overview of opening of a legal practice until the closure of the legal practice. It's a very long rule, but Legal Practice Council is here today to assist you to understand what the rule requires of you. Mr. Ashwin Reddy, the floor is yours. After Mr. Ashwin Reddy, and then there will be a session for Q&A. After the questions have been posted on the chat box, Mr. Tengoso will lead on the questions and answers. Mr. Ashwin Reddy will then be given an opportunity to answer questions, and then will then allow the next speaker on the issue of the drafting of bill of cost or the contingency fees agreement. We will be ordered by who is available at that time. Thank you very much. Mr. Ashwin Reddy, the floor is yours.
Thank you. Also, good afternoon, colleagues. Thank you for joining us for today's training session. My name is Ashwin Reddy. I'm a chartered accountant and registered auditor by profession. I've assisted the Legal Practice Council for a number of years in conducting inspection of trust accounts on behalf of the Legal Practice Council. I've had exposure to many of the pitfalls experienced by practitioners, and the objective of today's session is merely to create awareness with regards to the rules. So the session today is going to be roughly 20 to 30 minutes. So let's get stuck into it. Firstly, just the crux of the issue with regards to Rule 54 pertains to the trust accounts. I think it's important for us to consider what the objective of a trust account is firstly. And the main purpose of a trust account is essentially to keep trust monies separate from other monies. And this is the central point pertaining to a trust account. And it's a principle that needs to be maintained at all times. In terms of Section 86 of the Legal Practice Act, we get three types of trust accounts. You get your 86-2 trust account, which is your general trust account in which you will pool your various trust monies from all your trust creditors. You then get your Section 86-3 trust account, and this is a trust account that earns interest at a slightly higher rate than your normal Section 86-2 trust account. This account will be utilized where you invest trust monies, where you foresee that you won't need it for a sort of medium term. The benefit of the account obviously is that you earn higher interest, which then has an impact on your refund of your audit fees by the Legal Practitioners Fidelity Fund. And then lastly, you have your Section 86(4) trust account, and this is an investment account that's opened on instruction of your client, and the interest on this account accrues for the benefit of the client, save for an amount of 5% of that interest, which is payable to the LPFF. So just to quickly delve into the important considerations with regards to these investment accounts. Firstly, it's the practitioner's duty to ensure that these accounts are correctly designated as investment accounts in terms of Section 86(4). Oftentimes, we find that the banks do not correctly open these accounts. So sometimes in the outlying areas, just a normal investment account is opened. But again, ultimately, the duty remains on the practitioner to ensure that these accounts are correctly designated. The next point is that these investment accounts are for a specific purpose and for a specific legal matter. So there must be a legal nexus between the monies being invested and a legal matter being attended to by the practice. So example, in a conveyancing transaction where you receive a deposit in respect of a property transfer, and you know that those monies are not going to be required because registration is going to take roughly 3 to 4 months, then in such cases, it's appropriate then to invest in terms of Section 86(4). Then the last principle that needs to be maintained is that a practitioner shouldn't invest their own monies in terms of Section 86(4). This defeats the purpose of a trust account again. And it's basically the principle that your own monies should be kept separate from trust monies. In terms of Rule 54.17, there's specific rules with regards to the investment accounts. The first rule or the first aspect is that the investment can only be done in a trust savings or other interest-bearing account. The second
Good afternoon again. I'm not sure if I can audible. We seem to have lost Ashwin. Somebody looks like took control of the screen. Looks like somebody took control of the screen. Please avoid using the settings button on your screen. Somebody took control of the screen and we used and either interrupted with the recording. We are trying to get it sorted. Apologies. Apologies, colleagues. We're trying to get Mr. Reddy back. Please be patient. We're trying to get Mr. Reddy back. We seem to have lost connection.
Apologies, colleagues. The internet at our office got disconnected. Okay, just to get back where I dropped off, the Rule 54.17 governs the trust investment accounts, and the requirements are that the investment can only be made in a trust savings account or other interest-bearing account with a bank. Secondly, you have to obtain a client's consent before investing the monies. In practice, this is not always possible to obtain the client's consent before the investment, but you can invest the client's monies if you are acting in the best interest of the client, and you then obtain the client's consent as soon as possible thereafter. And then lastly, you have to ensure that the account again is correctly open in terms of Section 86(4). 54.16 creates a duty on practitioners to inform the RPC of your trust accounts that you have. So it is permissible to have multiple trust bank accounts. However, you do need to communicate with the RPC's records department and provide them with an account confirmation in respect of trust accounts that you open. In terms of Section 87(1), there's a duty to maintain trust accounting records. And if we look at the specific wording of it, it states that you have to keep records in respect of monies received and paid on its own account, monies received, held, or paid on account of any person, monies invested in a trust account or other interest-bearing account referred to in terms of Section 88, 86, and any interest on money so invested which is paid over or credited to it. In terms of Rule 54.6, a firm is required to maintain accounting records for both the business and your trust account. Section 87.3 then provides a definition of what accounting records means. And if we are now to unpack the definition, it talks to any record or document which relates to cash trust monies, your bank accounts in terms of Section 86, 2, 3, and 4, as well as any interest earned on those accounts, as well as any deceased estate, insolvent estate, or curatorship estate. So it doesn't matter in which capacity a practitioner acts, whether he's an executor, trustee, or curator, If he acts in any of those capacities, he then needs to maintain accounting records. And accounting records typically would relate to your cash book, your ledgers, your trial balances, and your trust creditor listings, your annual financial statements for your practice, your bank statements for both your business, trust, and your investment accounts, your liquidation and distribution accounts, receipts, proof of payments. In terms of Section 88, it echoes what I've said previously, which was the principle that trust monies need to be kept separate from other monies. Section 88 of the LPA states that any amounts held in a firm's trust bank account and trust investment accounts does not form part of the trust account practice and may not be attached by a creditor of the trust account practice or the legal practitioner. So this is why it's critically important for you to ensure that your accounts are correctly designated in terms of Section 86, 2, 3, and 4. Insofar as if the account is not an actual trust account and any money is held in those accounts, in the event of a practitioner's death, those monies would then be treated as part of a practitioner's estate. And secondly, it doesn't have the protection of the legal practitioner's fidelity fund. .10 states that the accounting records needs to be updated and balanced monthly. A practical example in this respect is if you have now completed the month of March, your accounting records for March 2024 need to be balanced and updated by the 30th of April at the latest. Retention of records. In terms of Rule 54.9, practitioners are required to retain all accounting records and all files relating to matters dealt with by the firm on behalf of its clients for at least 7 years. And the important part of this particular rule is that it's 7 years from the date of last entry recorded in each particular book, document, record, or file. So there's a practical example that we have. It's Advocate X who's received a deposit of 100,000 Rand in respect of a criminal matter from his client, Mr. Y, in January 2014. The matter was delayed due to various factors and complexities, and in June 2017, Advocate X received a further deposit of 100,000 Rand to continue with the matter, which is then subsequently settled in August 2017. On the 10th of September, Advocate X renders his invoice and final statement of account to Mr. Y and transfers his fees and disbursements to his business account. So the question then is, when can Advocate X destroy his client file? So if we properly consider the requirement in terms of Rule 54.9, we know that it's 7 years from your date of last entry. And in this case, the date of last entry is on 10th September 2017. That's when his retention period would start. And then lastly, the records need to be retained at the firm's office or branch office and may not be removed without the consent of the council. And in today's world where information is stored on cloud servers, the requirements are that the files must always be secured and the records and files must be immediately accessible to the practitioner and the council. In terms of Rule 54.14.7.1, there's a duty on a practitioner to safeguard trust monies. What this would then entail is for a practitioner to conduct a risk assessment at his practice, to identify the risks posed to his particular practice, and to design and implement controls in order to mitigate the risks that may affect his or her trust funds under his management. Internal controls should also be implemented throughout the period. Sorry, internal controls should be monitored throughout the period in which they're implemented. We then move on to Rule 54.14.14, and it deals with circumstances in which you may make a withdrawal from a trust account. In terms of the rules, you can only make a withdrawal from a trust account where you are effecting payment to or for a trust creditor, alternatively as a transfer to the business account in respect of fees and disbursements that are due to the firm. And the disbursements are due to the firm where a disbursement has already been incurred and paid, and alternatively where a contractual obligation has arisen on the part of the legal practice to pay the disbursement. And then the last requirement to that is that the fees and the disbursements have to be debited in the accounting records before you effect that fee transfer. (54.14.15.1) deals with payments that are made from the trust account. In terms of the rules, payments from the trust accounts can only be effected by way of check, which is no longer applicable. The checks have stopped with effect from 1 January 2021. So at the moment, you can only effect payment from a trust account via EFT. Cellular and telephone banking is not permissible. And when we talk about cellular banking, it does not relate to banking via an app on your phone or tablet. That is permissible, as that would enable you to effect an EFT. In terms of Rule 54.14.16.1, it deals with the time frame for the payment of interest earned on trust accounts to the legal practitioner's fidelity fund, which can be quickly summarized. In terms of your Section 86(2) trust accounts, the interest needs to be paid over to the fidelity fund on a monthly basis, and this needs to occur on or before the last day of the next succeeding month. The interest accrued on balances held in your Section 86(3) trust accounts those interests need to be paid over to the LPFF annually or before the last day of May each year in respect of a 12-month period which ends on February. And then in respect of your 86(4) trust accounts, only 5% of the interest earned on those accounts need to be paid over to the legal practitioner's fidelity fund on or before the last day of the next succeeding calendar month. So in essence, your 86(2) and your 86(4) interest need to be paid over to the fidelity fund on a monthly basis. Rule 54.21 onwards deals with the audit requirements. The LPC requires that practitioners appoint a registered auditor to conduct the audit of their trust account. This engagement should not be delegated to an accountant or bookkeeper. It's the duty of the legal practitioner to ensure that they appoint an auditor. So the audits that relate to your trust account, there are 3 types of audits. The first one is an opening audit. That's where you start your practice for the first time and you need to submit an audit report to the LPC within 6 months, covering the first 4 months of your practice. You then have your annual audit, and that needs to be submitted 6 months after your financial year end. In the majority of instances, your financial year end would typically be February, where, however, you do have a juristic entity. You may have elected to have a different financial year end, but the principle remains the same. You need to submit an audit report within 6 months after your financial year end. And then lastly, you have a closing audit report, and this is a audit report that you submit to the RPC when you close your practice, and it needs to be submitted within 3 months of you closing your practice. That concludes the session on Rule 54. If there's any questions.
Hi, Ashwin.
Hi, Nkosi.
Yes. We made a request due to the high number of people in attendance that they should they rather use that option of Q&A to post their questions.
Okay, so are we going to respond to it once this is completed?
The one question that I have now, one legal practitioner wanted to know whether we are going to send the slides as well as the recording after the session, and I said yes, we will do that.
Okay, yes, the slides will be available.
Yes. And
Okay.
I see someone is raising their hand, but we can't see who exactly it is. I'll request that that person must use that Q&A option. Then we'll read out the question.
It's Tondani. Tondani, you can just type out your question in the Q&A section, and we will then respond to you. Okay, that concludes my presentation. Debbie Nkosi, do you want to move to the next presenter?
All right, thank you so much, Ashwin. Colleagues, let me assure you that even at the end of this session, we will still read out your question and give and ask the presenters to respond to those questions. So we are going to open that window, but due to time constraint, allow me to call upon the second presenter by the name of Helen van Dijk, who will be doing a presentation on the drafting of bill of cost or legal fees. Helen, are you able to join? Helen? Okay, it looks like Helen is having some.
Hello.
Yes.
Hello.
Helen?
Yes. Can
Hello?
you hear me? Can you hear me?
We can hear you now.
Okay. Can you see me?
I can't see you yet.
Okay. That is maybe a good thing. Let me see. There we go. Can you now see me?
Yeah, we can see you now.
Okay. Excellent. Good afternoon. My name is Helen van Dijk. For those who don't know me, I am an attorney specializing in legal costs. I have about half an hour to present a lecture this afternoon, and I thought it prudent to spend the time discussing the amendments to the tariff that came into operation last week, Friday. I want to quickly run through the amendments with regards to the High Court tariff. I've sent through to Nkosi, maybe it can be of assistance, the excerpt from the rules, specifically Rule 67A. Guys, you must forgive me, I'm really not great with computers, but I'll try my best to work it on the screen. But if you could get Rule 67A of the Uniform Rules of Court in front of you, it would make your lives a lot easier. Perhaps, okay, there we go. Ms. Molefe, will you open, or whoever has control, just open Rule 67A. Right. While we wait for that, maybe you guys can find the rule on Google. There's been a major overhaul in respect of especially council's charges and the recovery of council's charges as between party and party. And that is what I want to discuss. You will know that Rule 69 specifically deals of the Uniform Rules of Court specifically deals with council's charges and also the allowance of the cost of more than one council on the scale as between party and party. Now, apart from the overhauling of Rule 69, the legislature has also included a new rule, to wit Rule 67 capital A, that starts with the heading costs. Now, if we could have a look at Rule 67A, and I just want to run through the what I consider to be the most important bits of that rule. It specifically now distinguishes between attorneys, as in normal, let's call it normal attorneys. There we go. Guys, can you see that? My screen is very small and I don't have control, but I hope that you can see it. And if you can't, just call it up on Google. Rule 67A deals specifically with costs, and it specifically deals with the cost of 3 types of people appearing. And you'll see under 67A1, small a, it says, it deals with costs of an attorney. This is in the normal sense of being an attorney, like we all are, with trust accounts, who sit in offices and assist clients and be the link between an attorney and between a client and an advocate. For attorneys, fees are taxed in accordance with Rule 70. Nothing has changed. We all know that Rule 70 deals with costs and that Rule 70 contains the party and party tariff. Then it expands whose costs are we talking about. And in 67A1B, it says, for attorneys with a right to appear in the superior courts and who appear in a matter in accordance with Rule 69 and 70, where applicable. To put this simply, it is when an attorney puts on the hat of an advocate and is no longer in his office, but appear in terms of the Appearance Act, specifically Section 4. To be able to do that, you know that you have to be admitted as an attorney with a right of appearance in the superior courts. There's something on the screen that, okay, never mind. Then it's been expounded further and it says, who else's costs are we dealing with in terms of 67A? For advocates in accordance with the tariff in Rule 69. So that indicates that from 67, we have to jump to 69. But then there's an exception, provided that for services rendered by an advocate referred to in Section 34(2), for work which is ordinarily performed by an attorney, the fees for such work shall be in terms of Rule 70. In other words, if you are a trust advocate and you are entitled to liaise directly with a client, a man on the street, you are to charge the fee that you do in your capacity as a legal practitioner, which in the past would have been known as an attorney. In other words, drafting of affidavits, sitting in your office, consulting with a client, taking instructions. Those fees are charged in terms of the normal party and party tariff as contained in Rule 70, except if this trust advocate appears in court. The minute he appears in court, he puts the hat of an, let's call it old school advocate on, and then his charges will be in terms of Rule 69. Good. Then it goes further in paragraph 2, 67A2. It says, in considering all relevant factors when awarding costs, the court may have regard to. People, this is not new. This has been the situation, the position since the beginning of time, that the court has a discretion in awarding costs and that the court takes all factors into account when cost orders are being made. So paragraph 2, a small a, says the provisions of Rule 41A, which deals with mediation, B, failure by any party or such party's legal representative to comply with 30A, that obviously is irregular proceedings. 37 is the pre-trial proceedings, and 37A is judicial case management. So if you're naughty, you don't comply with the rules, then obviously the court has a discretion. The court has always had a discretion. The legislature has simply put this in writing. Then paragraph C, the court will take into account, or the court may have regard to, unnecessary or prolix drafting, unnecessary annexures and unnecessary procedures followed. Nothing new to this. The court has a discretion. If you are garrulous, if you annex too many annexures, if you follow unnecessary procedures, the court may punish you when a cost order is awarded and exclude those costs that you have incurred. Unnecessary time spent in leading evidence, cross-examine witnesses and argument. Again, if you are garrulous, if you again and again address questions to the witness, same questions to the witness, the court may take that into account when an order is made. It is important to note that the taxing master does not have a discretion in this regard. The court, in other words, the presiding officer, has a discretion to decide to punish or reduce, disallow costs of these kinds of proceedings. Paragraph E, the conduct of the litigation, the conduct of the litigation by any party's legal representative, and whether such representative should be ordered to pay such costs in his or her personal capacity. That, of course, is the English way of saying costs should be paid de bonis propriis. It is important to know that de bonis propriis do not mean an attorney is going to pay the costs. It simply indicates that someone in a representative capacity is going to pay the costs. The order has to indicate who this person is. I've seen more de bonis propriis orders handed down against liquidators and trustees than I've seen against attorneys. Again, not new. It's only now been penned by the legislature. Previously, these factors were contained in the attorney's rules. That's now been replaced by the LPA, and in the conduct rules that goes with the Legal Practice Act, these factors are contained, to the best of my knowledge, in section 35. So it's clear that the legislature has now put the rules of conduct of the attorneys, or pinned that into the uniform rules of court. But don't think that the situation has changed, because this has been the way cost orders have been considered by judges from the start. Then a last factor is whether the litigation could have been conducted out of the magistrate's court. You can be punished if you conduct litigation that falls within the jurisdictional limit of the magistrate's court in the High Court. Also not new, but there's something that is very important, and that is that in the past, before this amendment, Rule 69(3), Rule 69 sub 3 specifically dealt with the position where you litigated out of the magistrate's court or out of the High Court when a matter fell within the jurisdictional limit of the High Court. And the punishment, quote unquote, for that was that cost would have been awarded on the magistrate's court scale, or could have been, or the court had a discretion in that regard. Right. So Rule 67A deals with whose costs are we talking about. It's been expanded to include advocates, trust advocates, and attorneys appearing. Rule 67A2 deals with factors to be taken into account. Very important, very important. Rule 67A sub 3A states the following. Please have a look at that. A cost order. Please take note. Any cost order. A cost order shall, it's prescriptive, indicate the scale in terms of Rule 69. Now, whose costs are dealt with in terms of Rule 69? Appearing practitioners. In other words, either attorneys who appear or advocates who appear, not attorneys sitting in their offices. I'm an attorney, I practice as an attorney. I suspect most of you are practicing attorneys. You sit in your office, your fee as between party and party is calculated in terms of Rule 70. Whose fees are calculated in terms of Rule 69? Advocates that appear and attorneys that appear. In other words, when you put the hat on of an advocate. Right, so it says a cost order shall indicate scale. You've got no choice. A cost order shall indicate the scale in terms of Rule 69, under which costs have been granted. And then I don't want to deal with B now, 3AB. I want I think it's Ms. Molefe who is kindly organizing the computer. If I could ask you to please put Rule 69 on the board. If you don't have Rule 69 or you can't see it, please quickly Google it. Right, have a look.
Can you see the screen? Sorry to interject.
Yes.
Okay.
Yes, I can. Thank you. Right, Rule 69 in the past said fees of advocates. It now states tariff of fees for legal practitioners who appear in the superior courts. In other words, it's been expanded to include attorneys who appear, and it's expanded to include advocates, trust advocates. Save where the court authorizes fees consequent upon the employment of more than one advocate or attorney. We're talking about an appearing attorney here. Because this attorney having the right of appearance in the superior court and who appears, there must be an actual attorney standing up in court. Alternatively, an advocate standing up in court. We are not talking about me for instance, who has the right of appearance, I beg your pardon, in terms of the Appearing Act, but I actually must, apart from attorney's work, also do the appearance. Right. So now it says, save where the court authorizes fees consequent upon the employment of more than one advocate or attorney having right of appearance and who appear to be included in what? Party and party bills of costs. Only such fees as are consequent upon the employment of one advocate or attorney having right of appearance in the superior courts and who appears shall be allowed as between party and party. It's important to note that as in the past, you need an order. In other words, the court must exercise its discretion. You need an order for the recovery of costs of more than one counsel, but it's been expanded to also include the cost of appearing attorneys or more than one counsel. More than one attorney. So theoretically, you would now be entitled to have 2 attorneys appearing as opposed to 2 advocates appearing. Good. And it's important in respect of party and party costs. With regards to punitive orders, the question immediately arises, so if you have a punitive award that allows costs as between attorney and client, would Rule 69 be prescriptive? And do you, in other words, require an order as between attorney and client to allow the costs of more than one advocate? And it seems to me, on a strict reading of the rule, that you don't require an order for to counsel in respect of attorney and client costs. However, considering the attitude adopted by the taxing masters, I suggest that when you have more than one appearing legal practitioner, please, please, please get an order for 2. So if you have 2 attorneys appearing, get up, the senior should say, I request costs as between attorney and client, including the costs of 2 legal practitioners. Failing which, although I disagree respectfully, the taxing master currently will not allow the cost of a second appearing party. That is, in any event, my personal experience. Right. Then it goes further. Very, very important. Look at Rule 69(2), where fees in respect of more than one advocate or attorney having right of appearance in the superior courts and who appears are allowed. So you've done your job. You've got an order for 2. The fees to be permitted in respect of any additional advocate or attorney shall be on a scale in terms of sub-rule 7. Important, as directed by the court. In the past, before this amendment, Rule 69(2) limited your second and consecutive counsel's charges to a maximum of 50% of the lead. So, put simply, if you had a silk who charged 4,000, I live in a dream world, but if you had a silk that charged a mere 4,000 per hour, your junior advocates' fees would automatically be limited to a maximum of 2,000 per hour. Now, the rule says, it is not a 50% limitation anymore. You need to ask your judge, your presiding officer, you need to ask the court to set the scale. To set the scale of the second attorney or advocate. But if you read this together with Rule 67A3A that we've read just before this, it indicates that a cost order shall indicate the scales. So put simply, it would appear, and respectfully towards the legislature, I have seen clearer legislation in my days, but it would appear as if one needs a scale to be decided by the court in respect of either one or more than one appearing advocate or attorney. So, if you have an advocate getting up in court, that advocate must know that he is supposed to ask the court to set his fee, if he's alone, at either scale A or scale B or scale C. And I base this, the fact that Rule 69(7) is binding on all advocates, regardless of whether it's a second advocate or a third advocate. I base that on the wording of Rule 67A3 that says, prescriptively, a cost order shall indicate the scale. So if you have one advocate, he should get up and say, my lord, I request that this application be granted with costs, comma, to include the cost of an advocate on scale A, B, or C. And if there's two advocates or two appearing attorneys, the lead should get up and say, my lord, I request that this application be granted with costs for the lead on scale A, B, or C, and the costs of my junior on scale A, B, or C. Now let's have a look, because it's scary and it gets scarier. Let's have a look at the scales. I specialize as a cost consultant. I tax many bills. I tax arbitration bills. And I can tell you now that we today in Pretoria, in a difficult matter, would get round about 4.245 per hour for your silk. If you argue vehemently and the matter warrants it, you may even get 4.8. In arbitrations, up to 5.5, depending on the kind of matter that we have. I know, interestingly enough, that Durban allows a higher day fee. Cape Town is more liberal insofar as these costs are concerned. Johannesburg is more conservative. But roughly, I reckon that any cost consultant who's worth his salt, and if a matter is complicated enough, should tax around 4,500 now in the year of our Lord 2024 for a silk. Let's have a look at the scales. The scales of fees contemplated by sub-rule 3 of Rule 67A shall be scale A, 3.75 per quarter of an hour or part thereof, and look at those scary words, maximum allowed. Scale B, 7.50 or part thereof, that takes you up, sorry, scale A takes you up to a max of 1.5. Scale B takes you up to a max of 3, and scale C takes you up to a max of 4.5. So it is now up to the advocate to convince the court to set the scale of his fees. And if there is, unfortunately, also a default position, and that is contained in section, you could just make a note, 67 capital A 3 sub C, that says the following: if the scale in terms of paragraph A is not indicated in the order. Paragraph A is the one that says a cost order shall indicate the scale. If the scale in terms of paragraph A is not indicated in the order, scale A shall apply. So if your advocate or your appearing attorney forgets, fails to, don't ask the court for an order indicating the scale, your default position is scale A. Now there's a suggestion that goes around that says your oh, there we go. Did I disappear? Am I back? Just indicate if someone can hear me.
We can still hear you.
Okay, great. Right. So the position is that even if you have a silk on brief, that nowadays a silk charges 6.5, 7, 8. I mean, the world is your oyster. But if you have a silk on brief and the silk fails to ask the court to specify the scale, your senior would be limited to a maximum of 1.5. And if there's a junior advocate and it is not specified, his fee would also be limited to a maximum of 1.5. The suggestion that goes around is that the taxing master has lost its discretion in totality. That is not correct. We are now being scrutinized not only by the courts, but also by the taxing master, because if you look at the scales, you will see that the amounts of 1.5, 3, and 4.5 are the maximums that can be allowed by the court, which indicates that the taxing master has a discretion to, even if you have an order on scale C, reduce your counsel's fee from a potential 4.5 to a suggested minimum of 3, being the maximum allowed by scale B. So it is extremely important that your orders, your draft orders, your heads of argument indicate that you are going to ask the court to provide costs for counsel on a scale, or then your appearing practitioner. And the scale must be specified for all 1 to 5 advocates that appear. Also important, to me, the most or the only advantage of this matter or this amendment is that your junior is not automatically reduced to 50% of your senior. So it seems to me that one could ask a judge in matters of severe complexity to allow the lead and the juniors charges at 4.5 per hour or on scale C. But let's assume you do, then the taxing master may still decide to reduce the second counsel's charges to something lesser than the lead. Yes, sorry, whoever is running the whiteboard, could I ask you to put 67A on again, please? Right, if you look at 67A3, please scroll down a bit. You will see, thank you, yes, a cost order. We back at the one with the punch, 67A3A. A cost order shall indicate the scale in terms of Rule 69 under which costs have been granted. And then it says, in considering the factors to award an appropriate scale of costs, the court may have regard to 1, the complexity of the matter, and 2, the value of the claim or importance of the relief sought. Again, nothing new to this. It has always been factors that the court took into account to make a decision as to whether two counsel should be awarded, or the cost of two counsel as between party and party. But now it's become part of the rules. Right. Yes, then something else I want to draw your attention to. Please move back to 69, the portion of Rule 69, and get that on the board, if I may be, may ask you to do that. '69. Right, under the scales, you will see, sorry, can I just say that, yeah, just keep it a little bit up, please, just a little bit up, that's it. Can you see that Rule 69.3 has been repealed? That is the old rule that dealt with magistrates' court jurisdiction. One would assume that if you are now in the High Court with a matter that falls within the jurisdiction of the Magistrates' Court, that the judge will reduce counsel's charges to scale A. But what is important is that there is no automatic on the Magistrates' Court scale for fees anymore. That has been repealed. So it's a factor that the court takes into account, but your attorney's fees are not reduced to Magistrates' Court tariff unless the court specifically orders that. All right. Then, if I can have a look at the tariff of fees that are dealt with under the scales in terms of 69.8. Very important. There's a little bit up, thank you. There's under paragraph 1 of sub 8, there's now a distinction between appearances on trial and appearances in motions, and I'm talking about opposed motions. Have a look at 8.1a. We're talking about the appearance fee of an attorney or an advocate in court. Appearance in court for trial. Your appearing party would be entitled to a day fee inclusive of preparation, consultation, and appearance on the same day. Right. My partner and I differ on this point, but you sometimes, not often, but you sometimes get advocates that on a heavy trial charge more than 10 hours on the trial days. In other words, they would charge appearance in court, and then tonight at 12 o'clock, they're still busy with preparation of heads, and they would say, I worked 15 hours, and they would charge the hourly rate multiplied by 15. This rule, she says she's taxed it like that. I've never been able to tax it like that, but it just goes to show if a proper argument is made. And I'm talking about her making a proper argument, because my day fees have always been limited to 10 hours. But this rule now takes care of that and specifically states that a day fee as between party and party is limited to 10 hours. An advocate can never be paid any more than 10 hours on a day. Right. But if you look at 8.3, a per quarter of an hour or part thereof preparation prior to the hearing. Now, for the more seasoned, let me use that word, the more seasoned attendees to this lecture, before 1990, council charged an all-inclusive elevated day fee. In other words, they would have added their preparation to their first day. So to take an example, if an advocate's hourly rate is 4,000 rands and he prepared an additional 10 hours to the first day of appearance, he would charge an elevated day fee of 80,000, 40 plus 40. And then his second and consecutive days would have been 2/3 of his elevated first day trial fee. In 1990, between 1990 and 1993, the bar started supporting council charging separate for preparation. And there's a case called Pretorius versus Santam. If you've got a pen, make a note of this, please. The citation is 2000 in brackets 2 close brackets SA 858T, Transvaal Provincial Division. It's a judgment by Van Dijkhorst, where Van Dijkhorst specifically does away with these elevated first day fees and says it leads to slow and inefficient work, and an advocate should be able to indicate precisely what time he spent preparing and what time he spent in court. So what this rule is now doing is bringing the rules in line with the case law. It won't have much of an effect in Pretoria and Johannesburg, because we here tax on the basis of straight up day fees, and then preparation is charged separately. I know that in Cape Town, they also do that, although City of Cape Town versus Arun indicates an elevated day fee still. It breaks it down and says you need the hours of preparation separately to that. But what I want you to know is that paragraph 3 tries or brings the rules in line with the practice, namely that preparation is charged separately. Right, that's the position with regards to trials, which I've dealt with under 8.1a. But now look at 8.1b. Appearances in court for opposed applications. 1, for the first day, a day fee, inclusive of preparation, consultation, and appearance on the same day. That means that on your first day of an opposed motion, the advocate would, as they do now, get a day fee for standing up in court. But on the second and subsequent days, his fee is now, in terms of 8.1b, limited to the time actually spent in court. For subsequent days, the rule states, per quarter of an hour or part thereof. So that means that for a big application, your fees would be limited as counsel, or recovery of your fees as between party and party is now limited to the time spent in court, which means that automatically your second day, you would be limited, or counsel would be limited to half a day fee in an application. Yeah, these large applications, huge applications that take as much work as a trial, and that's argued for more than one day, more than one full day. But even if it is argued for more than, or for a full second day, your fee for advocate will be limited to the time spent in court. This is not the position with a trial. Please remember that it's not the position with a trial, because trials are dealt with in terms of 8.1a that says appearances in court for trial, you get a day fee. And then in regards to paragraph 2, you get appearances in court for unopposed applications, but quarter of an hour or part thereof, subject to a minimum fee of 1 hour being allowed. Paragraph 3 deals with preparation, conferences, drafting or settling affidavits. Really nothing there has changed. But something important is paragraph 4. If you could just move that down a bit. And of course, Tim Nkosi, give me an indication of how much time I've got left, please. In the event that a trial or a post application is postponed, settled, or withdrawn, at the instance of any party on the day of hearing or before the first day's hearing, and a charge for the cancellation of the reservation fee of any day is levied, a reservation fee may be allowed as follows. If settled, withdrawn, postponed on the day of set down or 2 days before that, a full first day fee. This is the same as it used to be. You will get a fee for counsel equal to a full day fee if it's settled, withdrawn, postponed, whatever the case may be, 1 to 3 days before the trial. Oh, sorry, 1 to 2 days before the trial. If settled or postponed, 3 to 7 days, this is also the same, 2/3 of a day fee. Now, the last bit of fees that council could get up to 21 days have now fallen to the wayside. So if it's settled or postponed more than 7 days before the trial, council is not entitled to a reservation fee. What the position is with regards to attorneys that appear, only time will tell, because attorneys are not entitled to reservation fees. But if you look at the way this legislation has been worded, I think there's a reasonable argument that attorneys should also be entitled to a reservation fee. That's just my 2 cents on that point. Time will tell. One more thing I want to say, is this a good amendment or is this a bad amendment? And this is my own view. It's clear the legislature wants to reduce legal costs. The problem is that all it is doing through these amendments is widening the already chasm between genuine attorney and own client charges and party fees. And that negates, in my view, the logic behind Rule 70 sub 3 of the Uniform Rules that says, with a view to affording the party who has been awarded an order of costs a full indemnity for all costs, the taxing master shall on every taxation allow all reasonable charges. I don't know, respectfully, I don't know what the intention is of the legislature, and I also don't know why it's been done directly against the nature and the heart of Rule 70 sub 3, because all it's doing is it is putting the successful party in a worse position insofar as recovery is concerned. The I want to talk about is the amendment to Rule 70. Sorry, if whoever is running the whiteboard could just get Rule 70 up. It's a 5-page document, but I simply want to move to the third, to miscellaneous. Scroll down, please, up until the 3rd page.
Helene?
Yes.
I'm sorry to interject. Can I give you 3 minutes so that we get a chance to run through the questions?
Yes, you can give me 3 minutes.
Thank you.
I just wanted to say that it seems in terms of section D6, that on an urgent application, if one is now, sorry, can I ask you to scroll a little bit down, please? Down, 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 down. Right, little bit down, stop. Thank you. It says in blue, the fees in sections A, B, C, and D. A, B, C, and D deals with all the attendances that are contained in a bill of costs. Shall be increased, look at that, it is peremptory, shall be increased by 15% in accordance with any cost order made in terms of 67A4A and as allowed at taxation. Now see, don't go back, but 67A4A specifically deals with urgency and says if a matter is urgent, you can get a 15% surcharge. I personally don't believe you need an order. I think if you are successful with an urgent application, in other words, the matter moves on from urgency to merits, you are automatically entitled to a 15% increase on your fees, a surcharge. Of course, the taxing master still has a discretion to attack the individual items in your bill. But ultimately, at the end of the day, whatever is allowed may be increased by 15%. Guys, I'm sorry, I am over time. Is there, or are there any questions? Hit me now.
Okay. Okay, thanks. Helen, I've got questions here that I'll read out and then you can respond.
Yes.
Okay. The first one, it says, in case that N, the taxing master require a cost order for preparation for trial to be allowed on party and party. With regards to 3 in bracket A, can we claim without an order?
No, no, you can't claim it without an order. The point is exactly that. You must either have an order or an agreement in respect of scale B or scale C, failing which your advocate or appearing practitioner's fees will be limited to 1,500. In other words, let's just take a practical example. So we're ready to rock. We have an advocate on brief, he charges 3,000 an hour. Let's say he charges 3,000 an hour. The matter is settled the day before the time. Your draft order must now say, the matter is settled, plaintiff is entitled to his costs, including the cost of his counsel on scale B, by way of argument, because scale B is up to 3,000. If you don't have such an order, then it will be taxed on scale C. Obviously, if you have an order on scale B or scale C, then your counsel's preparation, drafting of papers, everything will be done at that hourly rate. So if you have an order, let's say on scale C, the taxing master decides to allow you 3,500 Rand per hour for your advocate, the advocate will charge that for drawing, consultations, attending, whatever the case may be.
Okay. The next one, if an attorney with the right of appearance appears at court and the firm has a specific hourly rate, for example, 3,500, but such attorney has had a right of appearance for 1 year, would this ultimately become an issue?
It will. It's the same as having an advocate who only has a year's experience and asks for an order on scale C. Definitely seniority will have an effect on that. Can I just say something? I was very upset when I saw this limitation on counsel's charges, especially because, you know, we tax in that region. So if this thing isn't increased soon, we're going to recover less in a year's time than what we recover at the moment. And then my partner very aptly pointed out that an attorney of any number of years of experience in terms of Rule 70 is currently limited at 1,552 per hour. So I suppose, I don't know, I don't know. Mikosi, I'm leaving that with them. If there's another question, I'll gladly answer it.
Okay. The maximum, is it a maximum allowed per hour or for the entire appearance?
Sorry, say again.
The maximum, is it a maximum allowed per hour or for
Yes.
the entire appearance?
No, no, yeah, no. In other words, let me just make sure I understand it. If you have an order on scale B, then the maximum that you can be allowed is 3,000. This is, of course, for your appearing party. And that is for all the work he's done. So he'll get 30,000 for the day on trial. If he's charged 10 hours preparation, he'll get an additional 30,000 for that. If he's consulted for 2 hours, he'll get 6,000 for that. And all of that will be added together, just the same as it's done at the moment.
Okay. All right. What sort of grounds or reasons can the appearing practitioner put to the court to convince the court to award a higher scale?
It seems to me that you are now bound in terms of 67A3 sub A by the factors stated in B, 2 and 3, as well as the factors stated in 67A2, because 67A3A says, in considering the factors to award an appropriate scale, the court may have regard to the complexity and the value. Yeah. Very important, I didn't mention this. This amendment it was published on the 8th of March, came into operation on the 12th of April. So if an advocate didn't get up this week in court and asked for a scale, he'll be limited, regardless of the complexity of the matter, to 1,500 rands an hour.
Okay. This is the last one. While we're waiting for Mr. Pentecost to take the floor.
Yes.
Where matters are settled on direct settlement, i.e. with the Road Accident Fund, and there is no court order, what will the approach be regarding the cost, and specifically the scaling provided for in the amendment, where the court order has to reflect or contain the council scale?
As I've said before, it is not good enough to settle on the basis that the defendant, being the RAF in this example, pays the costs. It must now say the RAF tenders the costs, including the costs of counsel or the appearing practitioner on scale A, B, or C. And you must get that. We have debated, what about an arbitration? Can one contract out of this? Of course you can. It depends what the arbitration agreement between the parties say. But if you appear in court, I fear you are stuck with Rule 69(7).
Okay, Helen, thank you so much for your time and your presentation. Backed by popular demand, I might have to organize another session, and I'll ask you to come and present, but that will depend to the audience.
Only a pleasure. Happy Friday to everyone. Bye-bye.
Thank you. Mr. Pentecost, are you ready?
You want me to start?
Yes.
Good afternoon to you all. I'm going to deal with the issue of the contingency fee agreement, and I must state that it's important that you understand that there are a lot of steps that have to be undertaken to ensure that the agreement can be validated, because I've had quite a lot of experience in dealing with disciplinary hearings where it's evident to me that attorneys are not complying with all the requirements. It's resulted in some attorneys being fined. We've even had suspensions and then odds striking off because they're not compliant, particularly in respect of charges. So please ensure that you cover all the steps, because if you don't, you will not be able to get the advantages of a contingency fee agreement. As you are aware, the contingency fee agreement was brought into play to assist clients who do not have the necessary funds to pay for a matter in the court. And it's covered by the Contingency Fee Agreement, so Contingency Fee Act, my apologies, 66 of 1997. It's a very short act, and you should make yourself familiar of it. The first, and remember that the Act covers both court proceedings and it also covers a matter going to arbitration. Before you enter into a contingency fee agreement, it's important that the attorney has considered the possibilities of the client being successful. So the success rate is extremely important. And you as an attorney, it's essential that you do that, because you enter into a contingency fee agreement and you haven't considered the prospects of success and you ultimately fail, you're going to end up covering all the costs yourself with no recovery. So it's important that you take a lot of consideration into whether you're going to be successful. I know you say, I've got a new client, I'll enter into contingency fee agreement, I'm going to make some money. And if you fail, you're not going to make any money. In fact, you're going to lose money. Because remember, you can only recover if you're successful in full or in part. And what is important, and it's the whole essence of the entire contingency fee agreement, what are you entitled to recover? You're entitled to recover a maximum of 25% of what is ordered or agreed. You can agree on a lesser amount or double your fees, whichever is the lesser. And there are so many examples which is becoming apparent that attorneys just take a straight 25% and they say, well, that's it, I've done my job, I'm entitled to that fee. You're not. It doesn't work like that. I recently dealt with an attorney who lodged a claim with the Road Accident Fund for his client for 2 million rand. The Road Accident Fund considered the claim, considered it to be a good claim, and they paid the 2 million rand. He just took 500,000 rand as his fee. And all he done was submit some papers to the RAF, completely out of order. He was not entitled to do that. And I'll deal with practical examples later in dealing with this particular matter. The contingency fee agreement must be in writing. And the Act specifically states what has to be contained in the agreement. And it must be signed by both you as the attorney and by the client. And you can also include the advocate, if necessary, in the contingency fee agreement, if he's prepared to be in part of it all. Invariably, they're not prepared to, but there are instances where they are prepared to be part of the contingency fee agreement. Before you enter into the agreement, certain things have to be covered. Number one, you must indicate to him that there are other ways in which he can finance this litigation. For example, he says, I don't want to be part of a contingency fee agreement. I'd rather pay the fees, or I might raise the funds through a loan, whatever it may be. It's imperative that you explain to him that if he is unsuccessful, he will be liable for the costs. So if the matter proceeds to court, his claim is dismissed with costs, he's going to be liable for those costs, which would be taxed. That's extremely important. Thirdly, you must explain to him how the fees will operate, how the 25% or the tax or your fees, how it's all going to operate. The whole agreement must be explained to him in detail. And if you don't do that, he might well say, subsequently, it wasn't explained to me, I want to be set aside. What do you put in the agreement? You must state what it relates to. Is it a court matter? Is it an arbitration? Some detail as to what this agreement relates to. You must indicate that it relates to the total success or partial success. Either it could be 100% damages or a percentage, whatever it may be. They must understand what the position is. The court may, for example, say you're entitled to 50% of your damages, but those are to be dealt with at a later date. He must understand that, how that's going to operate, whereby you've initially only proceeded on liability and subsequently the question of damages will be dealt with. What's important is that you have to set out a schedule of what your fees are, what your rates are, because he must know that, because at the end, if he's going to consider whether he's being overcharged based on double your fees, what those fees in fact are. You must get him to sign a power of attorney whereby he's instructed you to act in this matter. Remember, in terms of Rule 7 of the High Court, your opponent can call for a power of attorney to prove that you've been instructed to act in the matter. The question of disbursements and how they're going to be dealt with is extremely important, and I will deal with that in some detail shortly. You must the question of how the contingency fee will operate must be explained. It must be set out that you will take a percentage, whether it's 25% or a lesser amount, or double the fees, how it's going to operate. And he must be made aware that if the situation arises that you get a cost order in your favor, that you might wish to instruct a consultant, a tax consultant, like the lady who's just presented, and you will then be he would be liable for the fees. Let's deal with disbursements. That can be dealt with in two ways. First of all, you can agree that you will pay the disbursements on his behalf, and when you're successful at the end, you will then deduct those from the claim. Very risky to do that, because remember, if you're unsuccessful, you've incurred all these costs of experts, and you will not be able to recover those amounts. If you agree to do that, that you will disperse the monies on his behalf, then you are entitled to claim interest in respect of any monies that you have dispersed on his behalf, and you must stipulate what the rate of interest will be. The other solution, of course, is that you require him to pay, and he would have to then give you a deposit in respect of disbursements, and you will utilize that towards paying the disbursements that you have incurred. Excuse me. If in fact he gives you a deposit and you run out, you've paid, and you need further deposit, you can ask him to in fact provide you with a further deposit. Another possibility which you can consider is that you might try and reach an agreement with the experts that they will only bill you at the end of the matter. But again, you run the risk that if you're unsuccessful, again, you will then be bearing those costs. So it's important that, in fact, you deal with disbursements, and it's made very clear to the client what the position is. After you've entered into a contingency fee agreement, he does have the right to withdraw, but he's got 14 days within which to withdraw from the agreement. If he does withdraw, you are entitled to charge him the fees that you've incurred during that 14-day period, and he must understand that. Now, in terms of the Act, and this is important, and my experience is that very few attorneys are actually doing that. If you receive an offer of settlement in respect of a matter, before you can accept it, you need to draw an affidavit, which will be signed, which you sign, and which is put before the court. The affidavit must set out what the terms of the settlement are, the estimate of the amount you are likely to recover should the matter in fact have gone to court, what you believe your prospects of success are, what your fees would be at this point in time as opposed to what they may be should the matter go to court. All this that you have explained to the client, and he understands the situation, and that he must also sign an affidavit confirming that you have explained this to him, he accepts it, and that he wishes to proceed with the settlement. Those documents should then be filed at court together with the contingency fee agreement. Attorneys are not doing that. It's essential that you are required to do that. If having entered into a contingency fee agreement and you subsequently want to recover double your fees, he has the right to challenge the fees that you are charging, and he could take that to the LPC to ask them to review the fees that you've raised, and if an advocate's involved, that would be referred to the Bar Council. Now let's look at the situation of how you account. The question of 25% or whatever the number you've agreed upon, or double your fees, whichever is the lesser. That is important. It's whatever is the lesser. So let's look at the situation. And remember, this is where attorneys are failing down very badly. The majority of contingency fee agreements are with the RAF. And as you're advised, once they've agreed to effect payment, it normally takes about 180 days or longer, and the way things are operating at the moment, far longer before they can pay you. During that period of time, you should be drawing your bill, your account, your bill of costs, what you're going to charge. So that when the payment comes in from the road accident fund, you then are aware what is the lesser amount, the 25% or double my fees, because that's what you're entitled to charge. So giving a practical example, you get an agreement of the judgments for 2 million rand. Your costs are 200,000 rand. You double those costs, 400,000 rand. The 25% of contingency fee would be 500,000 rand. Therefore, you are not entitled to charge the 25% of 500,000. You're only entitled to charge the 400, which is double your fees, being the lesser amount. So accordingly, the client would get 1.6 million rand as a settlement, as opposed and not 1.5. I haven't dealt with disbursements in that particular example. If, on the other hand, the attorney's fees were 300,000 rand, he doubled them to 600,000 rand. The contingency fee of 25% was 500,000 rand. In those circumstances, he would then be entitled to the fee of 500,000 rand because it is lesser than double his fees. Let's look at the question of disbursements. If you have agreed that you will pay the disbursements on his behalf, once you receive the payment from the road accident fund, you can deduct those disbursements, the amount, before you account to him for what you have paid on his behalf. If, on the other hand, he has paid the disbursements to you, then those will come into play when you try and recover from the road accident fund. What happens if you have counsel in the matter? If the counsel has agreed to sign the contingency fee agreement, then the 25% or double the fees would in fact have to be shared between you and the advocate, and you'd have to agree that. If he didn't agree to the contingency fee agreement, then whatever his fees are would constitute a disbursement. If the situation arises that before the matter is resolved, your mandate is terminated by your client, you're then entitled to charge your normal fees from the time that he signed the contingency fee agreement until such time as your mandate has been terminated. Now, if in fact you get interest in terms of the judgment or the settlement, obviously you need to recover that interest, and that would be payable to the client and would not be part of the 25% taking into account the contingency fee. What's also important is that invariably, if you are successful, you get a cost order in your favor. You need then to start drawing the bill of costs and arrange for it to be taxed, because those costs are to the benefit of the client. It's not part of the double the fees or the 25%. It's over and above that. So if you tax the bill at 150,000 rand, those amounts need to be paid to him. So, and again, one's finding that attorneys are not bothering. They're saying, well, the matter's settled. I've taken my 25%. I'm not bothering about the costs. That needs to be dealt with. Clearly, there's a provision that you can get a tax consultant to assist you in respect of the recovery of those fees, and that would be payable by the client, but that you must make known to him. The next important factor is that in many cases, the client is a parent acting on behalf of a minor child, so the benefit is for the child. Those monies that are for the benefit of the child will be paid into a trust. So you have to make sure that it's a bank has normally been nominated and the monies are paid into the trust for the bank to administer on behalf of the minor, who will then deal with their needs. You'll be paying into that trust account the amount which would have been awarded to the client after the 25% or the fees plus disbursement, whatever it may be. And then in due course, when you recover the costs, the tax costs, those would also have to be paid into that account for the benefit of the client. So, as I say, there are a lot of steps that have to be undertaken to ensure that you're entitled to your recovery. Put it very simply, to end off, what are the timelines? What do you need to do? the first thing you need to do is to enter into the contingency fee agreement, and then you explain to them what it's all about, considered prospects. Once you've gone through those steps, you sign the contingency fee agreement, and you must ensure that all the requirements have been complied with. Secondly, once you obtain a judgment on your part or a settlement, then you need to draft the affidavits, which need to be put before court for the court to be satisfied that the requirements have been complied with. Thirdly, you need then, as soon as possible, to draw your bill of costs so that you can determine what you're entitled to be paid, the 25% or double your fees, whichever is the lesser. Fourthly, once the payment has been received, you need to pay the client, which will be at having determined what he's entitled to. Next, if you get a cost order, you need to then proceed to have the bill of costs taxed. And once that's been taxed, that amount has to be paid over to the client. Again, once you've deducted the costs of drawing the bill and attending the taxation. As I want to emphasize to you, I know a lot of attorneys are getting into trouble because they're not complying with the requirements of the contingency fee agreement. If you follow the steps which I've set out, if you follow the act, which is a very short act of what's required of you, and there's a template put up by the department setting out what is in a contingency fee agreement, and you do everything timelessly, you won't be into any trouble whatsoever, and it can be very successful to you. If not, you'll be in trouble, and that the agreement could be found to be invalid, and all you then entitled to is your normal fees, or if you committed further offences, you might find yourself in a disciplinary hearing. Thank you, Tembin Corsi. That's me.
Thank you so much, Mr. Pentecost. That was very, very informative. And I think right now, can we just run through these few questions?
Sure, no problem.
Yes, I'll just read them out, then you respond. The first one, it's coming from, I don't have to read out the name. So in a road accident fund, direct settlements, the parties should agree in writing as to the scale applicable if settled at the court doors, and counsel as being briefed.
Well, I say that they must then follow the directions that were given in the previous presentation as to what either if it goes before court, what they want the court to order, or if it's a settlement with the road accident fund, stipulate very clearly what's going to happen in respect of costs, so there can be no dispute once the matter goes before the taxing master.
Okay. I think this one is just a comment. Please also address that it is not applicable retrospectively.
Sorry, I didn't understand that.
I don't know what he was referring to, but he or she says, please also address that it is not applicable retrospectively.
Well, I'm trying to understand the question. I assume what the question is that can you, once you've started the proceedings, that can you somewhere along the way decide to enter into contingency fee agreement? That I don't believe you can do. It's got to be dealt with at the outset.
Okay. If you charge interest on the disbursement, should the company be registered in terms of the National Credit Act?
I think they should be, and you should make sure that you stipulate the rate of interest that you're going to be charging, and from what date it obviously would be payable from.
Okay. Is double the fee party and party fees or attorney and the client fee?
No, so that's why it's important that I said at the outset, when you enter into this agreement, one of the annexures you should be putting to your contingency fee agreement is your fee mandate, what you as a firm of attorney charges. For example, you say I charge 2,000 Rand an hour, hypothetically. So when you come to deal with the double the fees, you would then look at that statement of you've put out what your charges are, and you say I did something for 2 hours, I'm in 2,000 Rand, double that, it's 4,000 Rand. So there can be no dispute about it. You set out what your charges are at the outset. And then the client knows when it comes to the determination whether it's double your fees or 25%, he knows what you're entitled to charge because you've given him the schedule of your charges.
Okay. Regarding the affidavit to be filed at the court, but is the settlement not confidential between the litigating parties? Why then
No.
does the affidavit have to be filed at the court?
That's the requirement for the Act. It needs to be filed before the court. So it's an agreement, obviously, between the parties, the plaintiff and the defendant, and the judge needs to be made aware of what arrangement has been reached between the parties. I don't believe that document effectively should then become a public document. It's something that's only reserved for the judge to deal with.
The example of 2 million settlement is clear. What happens when CFA agreement is entered into and the order is for 400,000 while your fees and disbursement are about 200,000? How much is the attorney entitled to?
That's going to be a problem that you're facing, because if it's 400,000 rand and you've run up a couple of 100,000 rand of fees, you're only going to be entitled to 25%, which is in fact going to be 100,000. So that's why you need to look very carefully if you're going to enter into a contingency fee agreement and the claim is not that substantial and it's going to require a lot of work plus a huge amount of disbursements. You might be ill-advised to agree on a contingency fee agreement under those circumstances.
The clients are not aware that the attorney may only ask 25% or double their fees, whichever amount is lesser amount, because this sentence is only part of the discussion in the rough practitioner guide. So why don't they include this paragraph in the contingency fees agreement?
I think I made it clear it has to be included in the contingency fee agreement. It must be discussed up front how the fees are going to be dealt with, and it must be included in the contingency fee agreement. To say this, because it might be such that might be an agreement. I have seen one recently where they didn't take 25%; they only took 20%. So the litigant needs to know what the contingency fee percentage is, and that must be made very, very clear in the contingency fee agreement.
Can you agree on a lesser percentage of claim and tax cost?
Yes, you can. As I said, you can agree on lesser than 25%. As I said, you can have 20%. Then will be 20% or double your fees, whichever is the lesser. That's an agreement that you're going to be reached. The double your fees and the lesser still applies. It's only the percentage of the contingency which becomes applicable.
How is normal fees determined?
Normal fees, as I said, that's the situation which I've explained to you, that you put up your at the outset, and in fact all attorneys would end, whether it's a contingency fee agreement or any matter which you enter into with a client, you should be providing them. They should be signing you a mandate, and attached to the mandate should be your fee structure. This is how much you charge for per hour. This is how much you charge for correspondence in and out, whatever it may be. So that's what your normal fee is. They will know what it is. So there can be no dispute about it. It becomes important because when you determine double the fees, that's the document that you're utilizing. And if the situation is that he terminates your mandate, that's the document that you'll be using to determine what your fees are, what you're entitled. It's an important consideration, which I think many attorneys shy away from. They don't want to tell their client what, in fact, their charges are. You've got to be transparent about it. You've got to tell them, this is what I'm charging, so they are aware of what the situation is, and they can make then an educated determination at the end as to whether double your fees or 25% of the lesser, which it is, taking into account that mandate.
Does the 25% include VAT?
Sorry, does it include VAT? My apologies, I'm not sure about that. My understanding of the position, it doesn't include VAT, but it will include VAT in determining the amount on the taxation. Your 10% for attending taxation, etc. It does come into play in respect to that.
Okay, I'm not too sure whether this relates to the answer that you've given. May I charge VAT over and above the 25% amount?
Didn't get the question.
May I charge VAT over and above the 25% amount?
No.
That was quick. That was quick. If you have a cost order against a road accident fund, do I keep the tax fees over and above the 25%, or must I pay tax cost?
Certainly not. It's very clear. If there's a tax cost, those are the costs which your client is entitled to. You've already charged him the 25% or double your fees. You can't have a double claim. So that any tax costs that you recover following the taxation, that must be paid to the client. And as I said, the client is a minor, that amount will be paid to the bank who's attending to the trust on his behalf. That's a problem. I think two things are occurring. Number one, attorneys not even bothering to, once they've got their 25%, they say, well, I'm finished with this matter, I'm not concerned about it, whereas they should be taxing the bill, and they certainly cannot keep those costs.
What if the client recovers more than 25% on pari and party? Is the client then entitled to more than the capital that was awarded to him?
I didn't quite understand that. If he recovers more than 25%.
On pari and party?
No, so let's just understand the situation. We're dealing with you've got to distinguish between the capital and the costs. The capital determines the 25% or double the fees, whichever is the lesser. When it comes to costs, you tax the bill, and the bill which is taxed, the amount which is recovered is payable to the clients.
Okay. If we go to court and settle merits in a personal injury matter, and you are awarded costs, how much is the attorney entitled to in respect of cost? Can an attorney use the cost awarded to pay for experts for their client?
Well understood. That so you say a payment, you've reached an agreement as to you're going to be paid by the road accident fund, for example, and I didn't understand the question. What do they want to do in respect to the monies?
I don't know.
Just repeat the question.
Can I read it out again?
Yes, please do.
If we go to court and settle merits in a personal injury matter,
right,
and you are awarded costs, how much is the attorney entitled to in respect of cost? Can an attorney use the cost awarded to pay for experts for the client?
I've explained to you, we've got to distinguish in the capital and the costs. So you get, let's for example go back to where I was. Let's say you get the matter, you get 2 million rand plus costs. You take the 2 million rand and you then determine what your normal fees would have been, and you take double that amount and say which is the lesser, 25% being 500,000, or double my fees, whichever is the lesser. That is the amount I'm entitled to. Then you can then, if you've incurred disbursements on behalf of the client, you can deduct that from the amount that's payable to him, and he's paid the balance. When you then go and tax the bill, which you're entitled to do because you got a cost order, and in the bill you recover costs plus disbursements, which you've in fact deducted from what you paid him. Those amounts will all be payable to the client. All the costs go to the client from the tax bill. You've already taken into account your fees and disbursements before you paid him. Is that clear?
Yeah, I guess so. Ladies and gentlemen, due to time, I think it's 4 now, it's 4 o'clock. We have to close, but I have 3 more questions.
Let's deal with the 3 then.
Yes, okay. How do you determine an amount for normal fee? What would you say is a fair fee for consult per hour?
As I explained to you, right at the outset, before you start the matter, you set out a schedule of what your fees are, and you present that to the client and say, I'm going to charge you 2,000 Rand an hour, whatever it may be, in respect of consultations. He must be aware of that. If he's unhappy with that, he say, no, I'm not prepared to instruct you because your charges are too high. Once he's accepted that, that's your normal fees, and that's what you're entitled to charge because he's agreed to that, because it's an attachment to the contingency fee agreement, which he will initial at the foot.
In your 2 million example, did the attorney have to pay back the 500,000, or what is the position if you took the full 25% but later discovered that you were not entitled to 25% based on the amount of work done?
Well, as I said, that's why it's important, the timelines that I gave you. Before you get to a situation and you take your 25%, you should have drawn your bill of costs and you would then be able to determine what am I entitled to, 25% or double my fees, whichever is the lesser. That's what attorneys are currently doing, and that's why they're getting into trouble, because what they're doing, as soon as the payment comes in, they haven't bothered to draw an account, they just take 25%, and then there's a problem arises, and in fact they're going to be penalized. They're in fact liable to be subject to a disciplinary hearing by the LPC, because they've taken more what their entitlement is once it's found that their fees in fact are less, double their fees are less than the 25%. So you should not be doing that. You're getting yourself into trouble. You've got more than sufficient time that once the matter has been, the payment has been reached, there's a long delay before payment is made to you, and you've got more than sufficient time to draw your account to determine which it is, 25% or double your fees, whichever is the lesser. Do not just take the 25% and say, well, that's I'm done, because you're going to run into a lot of trouble.
Mr. Pentecost, with your permission, allow me to squeeze these two in.
Not a problem.
Good afternoon. You've mentioned that the contingency fee agreement is applicable to litigious matters. Does that include divorce matters? Mr. Pentecost? Ladies and gentlemen, I don't know, but it looks like we've lost Mr. Pentecost. I don't know, maybe let's give it 2 minutes to see whether he comes back or not. But on that note, I'm Tembingos, I'm a senior manager for library services. Should you wish to have another session, please send me an email. My email address is tembingosi n for November at lpc.org.za. It's Tembingosi n for November at lpc.org.za. Mr. Pentecost is back. Mr. Pentecost? Oh, it looks like we've lost him again. Ladies and gentlemen, I think on that note, I'm sorry to do this to you, but we seem to have no choice but to say we've come to the end of the session. Thank you so much for being such a good audience. You were really wonderful. And I hope that in our next coming sessions, you'll also behave and respond the same way you did to this one.
Can you hear me now?
Oh, yes.
Can you hear me now? Sorry,
okay.
Let's just finish the last two questions. He asked about a divorce. It certainly would not apply to a divorce matter.
Okay.
You're dealing with matters which are dealing with money. It's a court matter and arbitration, because you can't determine success rate based on a divorce. So it certainly can't apply to that.
The question is, if you get party and party cost on the merits, can you use it to pay the disbursements?
You can use it to pay the disbursements, but you should have dealt with it up front. You should have dealt with it up front when you drew your initial bill and you got a payment from the RAF for that. You could have deducted your disbursements then. You should have, so you'd be foolhardy not to deal with it at that point in time. But if you haven't done that, you can obviously, if you haven't recovered your disbursements at that stage, you could recover it from the cost that you get from your tax bill. But as I said, you should have dealt with that earlier, because when you draw your bill, you would include those disbursements, but you should have tried to recover them earlier.
Mr. Pentecost, thank you so much for your time and for your presentation. I think we've come to the end of our session. Please, if they happen to request that we have another session, I hope you respond positively to that request. Thank you so much.